So I've been driving around for the last 55 minutes. It only took 55 minutes to get here from Penn Station. Why are you here? I thought everyone today got in a car and they sort of drove around back and forth in New York City. It's very nice to be here. It's true. Thank you for the introduction. I have written other books. One was about economic regulation, administrative law. Somehow, I don't know how, that book found its way into the hands of a reviewer at the Los Angeles Times. In Alice in Wonderland, he wrote, Alice and the Dormouse come out of the pool of tears. The Dormouse begins to read from Hume's History of England. Why are you reading that, said Alice. Well, says the Dormouse, we're wet, and this is the driest thing I know. That was before Breyer wrote this book. Now, I've tried to make this, there are... So what is this book about? Why are we writing? Well, stop me before I write again. All right, but the point is that I noticed something, and you're really the audience, or it's certainly an important part of it. I noticed that we seem to be having, compared to when I joined the court more than 20 years ago, a very large number of cases, not the majority, but maybe 15%, 20%, where to decide these cases correctly, you have to know something about what goes on beyond our shores. You have to. I don't think there's much debate about it. And I wanted to show you that. Now, why? It's rather like this. I think I heard this example. I think it's a good example. If you like The Charterhouse of Parma, and if you haven't read it, it's a great novel, fabulous novel. The hero, Fabrice Del Dongo, starts off at Waterloo. And the bullets are flying, and the horses are running back and forth, and there's smoke, and Napoleon is running over here and there. And Del Dongo thinks to himself, he says, he says, something really important is happening here. I wish I knew what it was. And when I hear the words like interdependence, globalization, I tend to think, yeah, that's what I think. And I think a sort of cloud settles on my brain. So I thought perhaps by giving you, in a sense, a report from the front, very concrete examples of this area of our docket where you have to know something about what's happening from abroad. That's not an argument as to why we should cite foreign courts. What it is a report about what's happening. So you can say, we need this, we need that, or it might stimulate a little thought. Now, what kinds of areas am I talking about? Well, they're all over the place. Obviously, some are more gripping than others, but there are very few cases in our court that, at least for lawyers, are uninteresting. Which one do I want to give you as an example? Let's take New York. We're in New York. Dolly Phil Artiga. Dolly Phil Artiga came to New York in the 70s from Paraguay. She came because she'd heard and she found the man, also from Paraguay, here in New York City, who had tortured her brother to death in Paraguay. And she also found a law, a statute that was passed in the 1790s, really, in all likelihood, to help victims of pirates obtain damages. And she brought a case under that statute, which said something like an alien can sue in the federal courts of the United States to recover damages in tort, civil wrongs, for harms caused by a violation of the law of nations. Well, she said, that's torture. And she won her case, and she went back to Paraguay, and although she didn't get much money, she said, I came to New York to look that torturer in the eye, and I'm going back to Paraguay with so much more. Well, other people got the idea, and now there are quite a lot of cases in the federal courts that say, I was I was, victim of genocide, torture, etc. And suddenly, you begin to develop legal issues that have to be decided by the courts, including our court. Like what? Well, for example, obviously, who are today's pirates? What counts as piracy? What that did count as? That's one of the easier ones. Not that it's easy. But what are we to do in the cases in front of us if a victim of apartheid sues, as happened, and the South African government files a brief which says we don't want federal courts monkeying around with this. We have our own system. It's called Truth and Reconciliation. And the last thing we want is a group of federal judges awarding damages for or against these people, against this corporation, against some other corporation. Or suppose we have to ask, as we do when we try to answer these statutory questions, what those words mean. Are we going to interfere with laws of other nations that are roughly aiming at the same thing? And what limitations are they? And by the way, if we're not careful, before we know what we're doing, we will have an example over here that allows, let's say, some other country, I won't say which, to bring its own similar kinds of lawsuits. And it seems to me whenever this comes up, they're always going to sue Henry Kissinger. I don't know why he's the victim of all these things, but he seems to be. But the point is, when we are trying to work out these questions of interpretation, and they are difficult, we better take into account the idea of what will happen if other countries do the same. And we can't leave it up to the Supreme Court of the world because there is no Supreme Court of the world. And so we have to be thinking at the same time we're interpreting the words, and remember enough about the words to see they don't answer themselves. What other countries might do. And that's just an example. It's come up twice, very difficult cases, and we've decided all sorts of different things, which that is not my point at this moment, and we don't have time necessarily to go into that. Though you can ask whatever questions you want on anything. I'm not guaranteed to answer them, but I'll do my best. But you see, human rights area? Now, you're familiar with commerce. That's easy. I mean, no, it isn't easy. I mean, but it's there, of course. We have the student who was from Thailand and was studying in Cornell. And there he discovered that his textbooks, same textbook in English, is on sale in Bangkok for a much lower price. And he writes to his parents and says, send me a few. And they sent more than a few. And he began to sell them. And the publisher became a little irritated and brought a lawsuit under our copyright law. Now, whether he could do that or not depended upon the 6 words or 10 words or so in the middle of a copyright statute that you read those words and you tell me what they mean. I mean, my goodness, they are ambiguous and obscure, to say the least. But what is of interest to me right at this moment is the fact that I go into my office and I find a stack of briefs like that. I mean, briefs filed by lawyers in Asia, in Europe, governments of about 6 different countries, all over the world, and not just booksellers. Because we're told in one brief, copyright today is not just a question of books or books, films, music. An automobile has software copyrighted. Go into any store you want on that street over there, Fifth Avenue. You won't be able to because it's packed with cars, but still, you go into any street you want and you will see goods and they have labels and those labels are copyrighted. And at the end, he says, the writer of that brief, you will discover that your answer to this question will affect $3.2 trillion worth of commerce. Now, that's the world we're dealing with. Same kinds of problems where the plaintiff, antitrust case, is from Ecuador, vitamin distributor, sues a defendant claiming he's part of a cartel, which he was, turns out, a vitamin manufacturer in Holland, a big cartel of which there's one American member, and he wants to sue that Dutch company in New York. Or at why? Well, it could be that the price of vitamins was so high that they became too expensive and he got too weak and he couldn't get all the way to Europe. That's one possibility. Yeah, the other possibility is called treble damages and attorney's fees in our law. That's another possibility. He wanted to bring his lawsuit in New York, which he did, but can he? Can he? Now, to answer that question, just like asking the copyright question, or the securities question, same kind of problem, when the people injured are people who buy securities on an Australian exchange in an Australian company and the fraud happens in Florida. To answer those kinds of questions, you have to know something, if you are a judge, about how the European anti-cartel authority works, about how the SECs or their comparable authorities in Australia or in Europe and in other places of the world, how they work. Just as you have to know for the copyright case, how is copyright conducted abroad? How are they doing it? What do publishers do in terms of their practices that are relevant to this case? If they're publishers in their Asian subsidiaries or elsewhere, you just can't answer the question. And that's my point, unless you know something about what goes on beyond our own shores. And there are cases, case after case, like that. And in many instances, it doesn't divide the court at all. Justice Scalia wrote the case on the SEC thing, which I joined. I think I did. If I didn't, it wasn't about that. You see? Or take a major issue, which people write about, but there are very few cases, but there may be more. What about the problem of when we have national security interests over here, and we have the protection of basic civil liberties over there? That's an old problem, and there is no totally obvious answer. I mean, the Constitution of the United States gives authority to protect us, security problems, to the president and to the Congress, not to the courts. But it does give authority to protect basic human liberties to the court. That's certainly important and part of what they do. And so what happens when those two things conflict? You know, that didn't used to be so difficult. That's because for many hundreds of years, our courts, like courts across the world, followed what I think of as the dictum of Cicero. Cicero said about 2,000 years ago or so, he said, when arms, well, I translated it this way. I used to translate it as, when the cannons roar, the laws fall silent. That's a good translation, until somebody pointed out that the Romans didn't have cannons. And but you see the point. In time of war, no, just stay out of it. And we go back, look at Abraham Lincoln. I mean, my goodness. Abraham Lincoln, of course, he had a problem, didn't he? But tens of thousands of people imprisoned, civilians. And the Secretary of State, Seward, I think, called in the British minister at one point and said, you see that bell there? I can push that bell and have anyone I want in the state of New York arrested. I can push the bell twice and have anyone I want in the state of Indiana thrown into prison. Tell me. He said, does the Queen of England have such power? Mm-hmm. Fine, perhaps. Oh, the courts did get into this matter after the war was over, but not at the time. And look up the history of World War I and see what happened. That's Cicero. Stay out of it, judges. And then think of what happened in World War II, where 70,000 citizens, American citizens of Japanese origin, were taken from their homes in January, February, March of 42, and put in camps, prison camps, further east. On what evidence? None. Now, why do I say that? Because I looked it up. I mean, you're not going to find a person today, I don't think, who finds or thinks that General DeWitt went on the basis of evidence. And who was against that? J. Edgar Hoover. He said, don't do it. No need. Who was for it? Earl Warren, who later said that was one of the worst things I did. Well, he wasn't happy about it, having done it. But they did do it. And then the case went to the Supreme Court. Why? Because Fred Korematsu, whom I once met, represented by Ernie Bezig, who was the ACLU lawyer out in San Francisco. My father used to play poker with him. And the ACLU wouldn't sign the brief. Pearl Harbor, December. This is just January, February. But Korematsu, whom I once met because of that connection, our next-door neighbor was Ernie Besig's daughter up in Cambridge. And I met him, a feisty guy, liked him very much. And he was not going to have anything to do with this. He says, I'm an American. And his parents had said, don't rock the boat. He said, no, I'm rocking it. And they brought the case. The case went up to the Supreme Court in 1944. And in 1944, he thought he'd win. Besig thought he would win. Two lawyers in the Justice Department really looked into it, Burling and Ennis. And DeWitt had said there were 743 instances of messages being sent to Japanese submarines. Somebody's sending those from San Francisco. And he said, look, what is that about? The FCC came in with a stack of documents like this about 2 weeks later, and they said, well, what were those messages? He says, not one. There wasn't one. He says, there were all things like buck privates who didn't know how to work the equipment. Well, how did you do this so quickly? He says, oh, we did it at the time, and we showed it to General DeWitt, and he knew at the time. And J. Edgar Hoover had told him, actually, he didn't tell him about all the instances of sabotage, because 4 out of the 5 so-called instances happened after they were removed from San Francisco. You say, there was nothing. But 6 members of the court, including great liberals written by Black, Douglas, Frankfurter, the ones who wrote Brown versus Board, no, they decided for the government. It was Jackson, Roberts, Murphy. And Murphy wrote the great opinion. But he said there's nothing behind this except race. But I asked myself, why did they decide that way? Cicero. There it is. Someone has to run this. Someone has to run this war. Roosevelt or us? You say? And we can't run it, so we better let Roosevelt. Now, you see where Cicero gets us? And he did. And I think the big change came about in the Korean War, where some of us will remember that President Truman seized the steel mills. And that went to the Supreme Court, and the Supreme Court said no, just about the first time during the war. Because Truman had said, with a lot of evidence, I got to seize the mills, otherwise there'll be a strike, and we will not be able to get the necessary munitions to the army fighting in Korea. And there's a lot to that. They said, no, gone too far. And then we've had 4 Guantanamo cases, 4. In each of those 4 cases, the petitioner was a detainee in Guantanamo, being kept there. And not the most popular person in the United States, bin Laden's chauffeur being one of them, against the president, a very powerful person, Secretary of Defense. The 4-1, each of those cases, including the case which I think is probably the most significant, where Congress had passed a law saying those Guantanamo prisoners do not have access to the American courts. And the majority of our court said, yes, they do. Because the Constitution says the writ of habeas corpus shall not be suspended except during time of insurrection or rebellion. This is not an insurrection, it's not a rebellion. You see? That's a change. That's a change. Now, to tie that in directly to what you think about, I think the best line from the point of view of explaining to people what we were doing was Sandra O'Connor's, which I joined, and she said, the president, the Constitution does not write the president a blank check, not even in time of war. Very well. You're immediately thinking, no blank check. Fine. What kind of a check does it write? And we didn't say. And we were criticized a lot for not having spelled it all out. What? Why wouldn't we spell it all out? Because I don't know. I don't know how to spell it out. I don't know what the answer to these questions that will be coming up is. We proceed case by case. We perceive why, and how wise it is, in my opinion, to do that in this instance. Because there are real security threats. And you can't just automatically say the president has no power or that he has every power. You say, has every power, we're back to Guantanamo. Not Guantanamo, we're back to Korematsu. And you say he has no power? Well, please. Jackson said that the Constitution is not a suicide pact. So once we're in this area of blank check, well, what kind of check? Now you're facing a very realistic problem that we're actually likely to have in First Amendment areas, in Fourth Amendment areas, in 14th and Fifth Amendment due process, no imprisonment without due process, lots of areas. And once you see that we who are 9 fallible people are going to have to answer some of these questions, I think you'll see why I say we have to know perhaps more than we are likely to know. What is the nature of the security problem? And how do we find out? And what do they do in other countries? Not that we're going to copy them, but it might help. We're not the only democracy in the world. We're not the only people who want to protect human rights. And so maybe it would be helpful to know, say, what England does, or say what France, or say Israel, which has this problem every day of the week. Now, you see, all I've done is with a long story, a long wind-up, and a very short pitch on this one, which I think is quite important, is to put you in the position that we're in. The short pitch being, well, how do we? How do we learn? The lawyers, of course, help. The lawyers are armed with at least 2 great questions. And when they're defending somebody who is going to be thrown into jail for a reason that's an unusual reason, let's say, here, or in prison, the first question they'll ask is why? That's a great question. And the government then has to explain it. And maybe, I'm not saying it's so or not so, but if they can't explain it for security reasons, we'll develop systems which are partly in camera. In Israel, they say the army can come in and go in camera and even keep the lawyer away from this person. But the judge has to approve it for a very short time, and they have to come in tomorrow and give a better reason why they're still, you see? And the day after that, they better come in again, and the day after that. So there are all kinds of systems around. There are all kinds of problems. There are all kinds of answers. There's all kinds of information. And that's where we are. You want to go into the areas of treaties? There's even more. I'll end with that one. But one thing that really puzzled me, was why are we interpreting a treaty, the Hague Convention on Abduction of Children, a matter that every domestic relations judge in this country knows something about? And what a tough job that is, a domestic relations judge. State court judges. Very experienced, and a matter that we know nothing about. Nothing. We are not domestic relations judges. We don't have that experience. And why suddenly is it in front of us? Because it's in a treaty. Why is it in a treaty? Because marriages today are more and more international. And they cross national boundaries. And we have to know what's going to happen to children. And we have over here the groups of people who very strongly spend a lot of their lives trying to prevent child abduction. And we have over here on the opposite side groups of people who spend a lot of their lives trying to prevent spousal abuse, which quite often leads to child abduction. And we're interpreting that we might get that one wrong too, in which case they better be prepared to change the treaty. Well, I'm trying to draw a picture, and the picture is of a world in front of us. And that world in front of us is part of this broader world, which is called the world of interdependence. And how are we dealing with that in general? All kinds of ways. I got some information from Professor Cassisi's effort to try to find out how many, and you may know the answer to this, how many organizations are there now in the world created by treaty or by executive agreement, or in some other way, that as a practical matter have little bureaucracies, and those little bureaucracies advance rules which are then approved and which then affect citizens and businesses in more than one nation. How many such entities are there? Big ones Little ones? Medium ones? How many think there are more than 100? This is an informed group. More than 500? More than 1,000? That's pretty good. More than 2,000? Yeah, there are probably more than 2,000. 2,000. We belong to several hundred. There's something called the yearbook that lists the ones we belong to, and it just goes on and on and on. I mean, they range from the United Nations on the one hand and the International Trade Organization down to the important International Olive Oil Council. I think that's a good one. And there's also the Bluefin Whale Commission. And the most important, which people don't realize because of its odd creation, it's a corporation in California and has its headquarters in Los Angeles. It's called ICON. And they deal with internet, and they have the domain names, and they affect the lives of every person here. And we in the future are going to have to decide what the status legally of some of these rules, etc., is. What is it? I mean, if we say, no, you cannot, Congress, or delegate to these groups the authority to make rules, laws, we can't solve the problems of the world. Can we? Or we can't help, not that we'll solve them. But if we say the sky's the limit, well, what happened to Article 1, which gave Congress the power to legislate? The Europeans are facing this problem and have faced it right now when the German court tries to decide how much authority can Germany delegate to the EU to make binding rules. Same problem in Italy, same problem in Austria. And I'm not saying we have decided it, we haven't. But it's just sitting there, along with a lot of others. And why is it important, as I say, for me to write a book about this? Why? Well, it's there, the problem's there, people might as well know it. I mean, these problems are there, but I do believe it's something more than that. I do think it's part of an effort which Sandra O'Connor and I really sensed in 9/11. We were in India. And we were talking to the judges there, and we look at the television at the place where we were having dinner, and my God, we saw what was happening here. And the people in India could not have been nicer. I mean, the judge, very sympathetic. The judges, the lawyers, everybody we met. And we came away, which we're talking about, with one impression that geographical distinctions are not the distinctions that matter. What matters is really perhaps a distinction between those who believe in a rule of law to help resolve the world's problems, and those who don't, and think there are other ways, which I try to explain to some of the students some of the time. You don't like the court's decision, go turn on the television, and you see what happens in countries that have other ways of solving their problems. And we're on the right side on that one. But we have to prove that we have a point. And I think in a way we have to prove it by saying these great problems of the world can in fact be resolved. It's not impossible. Systems can work. And we know we have a very complex one. We know anything to do with law is very complicated, and we know it's tough to get these things decided, but here we're trying to decide what matters worse cooperatively with other countries and set up organizations and rules and so forth that will help resolve the problems of the world, whether they're environmental or strategic and have to do with security or health or commerce, all of which are international. And by showing that these at least can help work, I think we help to prove something. And we want to prove it, it's perfectly obvious. I love Camus. Is it too corny to quote that? So it is a little corny. But my goodness, I believe it. If you like to read, I'll end with that then. At the end of the Plague, which I think is a great book, it speaks to my generation. He's writing about Oran and the plague that took over Oran in Algeria. And it's really a metaphor for the Nazis in France. And he says at the end, why have I told this story? And he says, I've told the story to show what they went through during the plague. And also I want to talk about being a doctor, because a doctor is a person who just does good without thinking about why. Tries to help. But more importantly, or not more importantly, but he says, really, I want to say this because the bacillus, the plague germ never dies, never dies. It just goes into remission. And it stays there. And he says the attics and the suitcases and the hallways and the papers and so forth to emerge one day for the education or to the misfortune of mankind to send its rats once again into a once happy city. All right, well, law and so forth is self-serving, but law is just one weapon people have against the reemergence of that plague germ. And I think we all have an interest in showing that it works, and I want you to know about it, and that's why I write the book. Yes, sir.
I wanted to ask you about a case, the implications of a case from which you dissented, which is Medellin. Or previous to that case, the ordinary understanding had been that treaties of the United States were presumptively self-executing, that they applied domestically. That's according to the Supremacy Clause, according to the original understanding. That's one of the reasons we had the Constitutional Convention. But as you point out in the dissent, that case seems to have reversed that idea in asking for a clear statement of self-execution, which you're never going to find in a multilateral treaty, which of course is the vast majority of treaties today. What are the implications of that majority decision, and have you seen the effects of that decision go one way or the other?
Now, this is a very technical question, but it is a good question. I'll tell you what is it, you have these treaties, and the treaties have a lot of different provisions. And the problem comes up of, well, there's a provision in a treaty and it says do thus and so. We promise to do it, okay? So does Congress have to pass a law before it becomes internal law of the United States? So the courts will say, do it, or don't do it, depending on what it says. Or is it okay that just automatically it becomes law? So the courts, even if Congress sits around and does nothing about it, that provision, the courts will enforce it. And I would have said that the rule for years and years, in my opinion, which was a dissenting opinion, which so often is right, but then why didn't they listen? I think from John Marshall on, it went something like this. Look at that provision. Look at that provision. And tell me, is it really a political matter? Does it say take the Marines out of Nicaragua? Does it say we'll peace and war? If so, courts stay away from it. It's up to Congress to pass it or not. But suppose it says we will let an Italian in Iowa who has just inherited his mother's silverware obtain the silverware if the Italians in Italy let the Iowans obtain the silverware from his mother over here, okay? So that's a pretty technical matter. And there are a lot of these technical matters. And he says, a technical matter? A matter that judges normally decide. They take effect automatically. All right, now in this very dramatic case, which was dramatic because it involved the president, it involved the death penalty, it involved Texas, the president wrote to Texas, we had agreed that we would follow the International Court of Justice, and the International Court of Justice interpreted this thing a certain way, and President Bush wrote to the governor of Texas and said, do what they say, please. Oh, Texas being Texas says, no. Okay. No, we won't. Okay. So then it's a case for us. And I dissented because I thought that they should have to do it, and the majority didn't. And so now is this going to ruin, does this really make a big difference in treaty? The answer to that is I'm not sure. Congress could, in fact, easily get around it by simply passing a statute, several versions of which I very secretly suggest in this book, but and very diplomatically, or it may not matter that much because in order to ratify a treaty, you have to have 2/3 of the Senate, and in order to pass a law, you have to have 2/3 of the, you have to have 50% of the Senate, but 50% of the House as well. So is there going to be an instance where you can get the first but not the second? All those are raised. So the answer is I don't know. Yes.
Yes, and you brings it seems to be two different categories of issues. One is where another country or countries have a set of experiences and ways of doing things, which could inform the judge's view of what works and what doesn't, sort of the Deng Xiaoping, whether the cat catches mice or not. But the other class of problems, it seems to me, that you raise is a very different type of class, and that is a class of problems of the threat of counteraction. If we arrest somebody, the Iranians may torture somebody, and therefore maybe we shouldn't arrest them because you're going to end up with this result happening there, or because we prosecuted antitrust violation here, I know well Microsoft and Google were going to be through 20 years and $200 million worth of European investigation. And I'm wondering if you could comment on whether you see a difference in what should be the openness of the court to the one type of data versus the other type of data.
That's interesting. I hadn't thought of it in that way. But in making that distinction, I think the first kind of a problem is more likely to be a problem we'll take into account. The second kind of problem, where if you do this, they'll do that, is more likely to come before us in the form of a State Department brief. And the State Department won't put it quite in those terms. They'll say it's important that I don't know how they'll put it. Because that there's a threat of this, if you do that, is not something that's likely to cut a lot of weight with the judge, because we're not that practical, you see. But maybe you can put it into the first form, and I'll show you how say in an antitrust case, we're trying to figure out certain kind of rules involving whether a company could get some information from another company in California under a statute that gives people the right to get information from other people if they're going to use it to give to an authority, a tribunal in the third country. And they said, we want to give it to the European Cartel Authority. And the European Cartel Authority said, we don't want it. But we're interpreting the statute. Should we take that into account? And they filed a brief that said, look, one of our problems is, and that was true in the other case in Ecuador too, they said, one of our problems is this. We have a program, the way we operate our antitrust enforcement authority, that we have a whistleblower statute. And we give people who are members of cartels immunity if they come in and tell us what's going on. And that may not be so nice, but it works. And if you decide this the wrong way, it's going to be very hard for us to run our program. And that will hurt us a lot. Now, the court did listen to that and put it in the opinion. And what I say that's an example of, it's an example of you don't want to interpret American law. It's always been true. It goes under a word that nobody understands called comedy. You don't want to interpret an American law in a way that interferes with another country's law. You want to minimize that. But I'd say it's more than that. What we're trying to figure out in those cases is how to harmonize so that the antitrust enforcement authority in Europe and that in the United States can work together, can work without running into each other. And that was true of the SEC case, too, in Australia. And that kind of thing is a change, I think. It's looking for ways of bringing similar institutions in different countries into a legal world where they're not at each other's throats. You see, that's not direct threat and so forth. It's an effort to harmonize. And that is, we have to do that more and more as they affect each other more and more. And to do that, you have to know how the other works. So that's right there. The thing of, well, they're going to punish us if we punish, that is distant, less likely to come up. And we have to, I have a harder time thinking of instances. Yes, sir.
I'm wondering how much of your premise,
Ma'am.
yes, thank you, has to do with the fact that Mrs. Altman was able to get the woman in gold, the Gustav
that was a
Klimt
great
painting.
case. That was a great case. I'm not sure that, did you see that? Yeah. It didn't depict the Supreme Court very accurately, but I guess only 9 of us had an adverse reaction on that basis. It was a good film. That was a very, very interesting case. See, she brought the case, the question, it was a pretty technical question as it came to us. My recollection is that she could bring a lawsuit against the Austrian government, and the museum was part of the government, if but only if they were engaged in commercial activity. Now, they were engaged in commercial activity in the United States when she brought the lawsuit, because they had a gift shop, and they sold all kinds of things, all over the world. But they hadn't been engaged in commercial activity at the time they received the paintings from the Nazis. And so do you interpret that provision, meaning engaged now or engaged then, or what? And we looked into that, and I think we eventually said the fact that the purpose, it's actually behind one of the things, I'll show you in a second. I think we actually decided that if they're engaged in commercial activity now, you can sue them, even though they weren't then. And if you want to get the idea of the rationale, I love this case, and it's a real case, but I don't think we put it in. It's in France, and it was King Farouk. And King Farouk didn't pay his wife's dress bills to Christian Dior, who sued him. And that was after he left being king. He was thrown out, and he was living in the south of France, I think. So the French court said, he says, but I have sovereign immunity. I am the king. And they say, you were the king. You're not the king now. And sovereign immunity has to do with who has the immunity now. It's a thing. And you see, by converse, you fool around with that, and you'll see how we got to our answer. Yes?
First of all, Justice, thank you for your service. Thank you for being here. COP21 in Paris, in the climate accord, climate agreement this week, is particularly interesting, obviously, to a lot of people globally. You talk about interdependency, you talk about globalization. In New York, we know that there's the idea of looking at the Martin Act to hold Exxon accountable for maybe not disclosing some material factors associated with the investment case. So that seems like an interesting approach. But can you comment at all about the perspective of the Supreme Court on the climate agreement and what could happen going forward? Anything you could share? And in particular, this Schneiderman action is
You have
interesting.
enormous faith in what I might or might not know. I haven't read the climate agreement, and if I have to read it, it might well be because there's a case in front of us. In which case, there's another reason, aside from just ignorance, which should be good enough, that I can't comment on it. And the reason usually, which isn't a point worth making, is a general point. The reason that we can't comment on cases that might come in front of us is because the case that comes before us goes through a process. It's a decision-making process. And it involves, as we were talking about earlier at lunch, that I will read briefs, maybe 15 or 20 or sometimes 30 or sometimes more in a case. And then having done that, I'll ask my law clerks to write memos on parts that I'm not certain about. And then I'll have another discussion with them. And then we'll have an oral procedure of probably only half an hour, but it's for us to ask questions because we think we know the arguments. And then we discuss the cases in conference. And then as a result of our discussion by ourselves in the conference, we go and we write opinions. And when I write it, that can take 2 or 3 months. And writing something down is a very good discipline as to whether you're thinking about it sensibly or not. And people might write dissents, and I might respond to those. And sometimes we change. And so by the time you've been through that process, your answer might be different from what it would have been if you just answered a question in an informal context when you hadn't really thought it through. And so that's a good reason why there is this principle of not commenting on cases that might be before us. But I also have the advantage of ignorance. Yes?
Harmonization and global harmonization, it's usually sovereign to sovereign. How do you incorporate states' rights and New York State Banking Commission? New York State Banking Commission.
What's the role of the states in all this? That's really what you're saying. And there is another, we came close to having a case on that. It was a case called Bond. And It involves some odd facts. There was a woman, I think in Ohio, is that right? I think it was Ohio, but I'm not positive. But her best friend, it turns out, unfortunately, was having a love affair with her husband and had a child, and the husband was the father, and that annoyed her a little bit. And she worked in a photo shop, and she found these chemicals that she thought would really fix this woman by causing a few painful rashes and things. So she smeared them on the doorknob of the friend's house, put friend in quotes, and unfortunately, what she didn't know is once they're smeared on the doorknob, they turn bright red. So the friend came out and saw this and phoned the postal inspectors. And the police said phone the postal inspectors, and they did, and she was ultimately arrested, and the government, in its wisdom, decided to prosecute her for violation of the Chemical Weapons Treaty, which carries with it a very heavy penalty. And she said, you can't do this. This is among other things, this is a minor state law crime, and Congress has no business in passing a statute, even though it copies the words of the Chemical Weapons Treaty, punishing me for this. It's up to the states. Now, we could have, perhaps, decided a major question, which is whether Congress does have the power, because of a treaty, to pass a law that without the treaty, the Constitution would not give it the power to pass. There's a famous case on that called Missouri versus Holland, which involved some wild birds that flew over the United States. And Justice Holmes said, yeah, a treaty can give Congress the power to pass a law they otherwise couldn't. There's always been a lot of argument about that. When I was younger, there was the Bricker Amendment, and you're too young for that, but nonetheless, it's always, but we, for better or for worse, I think from our point of view for better, we didn't really get into that question. And we just said, well, we assume that Congress, unless it says so on a matter this detailed belonging to the states, does not intend the words to be quite as broad as they might otherwise have been. It's filled with interesting examples. I mean, they define chemical in terms of anything that would make sick or kill a man or animal. So I think Chief Justice Roberts wrote the opinion. He put in something like, so I have evil thoughts about killing my child's canary, because if I violated the Chemical Weapons Treaty, that's et cetera. But there you see, we avoided it, as we do sometimes. And therefore, I don't have a good answer to your question, but I couldn't resist telling the story. Yes.
What was the result of the copyright?
The copyright, the student won. Student won. And I wrote the opinion, actually. I mean, think if you, see what you don't know, which I didn't, because I didn't tell you probably, is that if you go into a bookstore and you buy a book, you can do what you want with it. The copyright holder loses. It's called the first sale doctrine. And the question is, does that apply abroad? If you go into an auto shop, you buy the Toyota here, do what you want. Now, wait, does it make a difference? Ah, Toyota. Does it make a difference that it came from Japan? And we said, no, it didn't make a difference. Didn't make a difference. All right, yes, I'll get back there.
To my knowledge, President Obama is trying to pass an executive order to implement the climate change policy passed in Paris on the COP21. Oh, thank you. My question is, based on the Constitution, does the president have the power to do such a thing, or does Congress have to pass it as if it were a treaty?
I'll give you the same answer I gave to this excellent question there. This is an excellent question, and unfortunately, I have to answer it the same way. From your point of view, unfortunately. From my point of view, fortunately. Yes, sir.
Mr. Justice, I greatly appreciate your trying to drag the world into the court. It's quite an undertaking. I also appreciate your mentioning building the line at the beginning of your lecture, because I was building the line as lawyer.
Oh my goodness, have I got that right, do you think?
And by the same token, I was quite disappointed by your concurrence in the Kiobel case, which greatly restricted the scope of the Alien Tort Statute. And my question is this. You said in the Kiobel concurrence that one of the situations in which the Alien Tort Statute would continue to apply was where the defendant's conduct substantially and adversely affects an important American interest. And my question is, why is the promotion of human rights throughout the world not an important American interest for this purpose?
Well, he, like most opinions, I can't defend my opinion. You have to read what the majority said. You have to read what the dissent said. You have to ask the questions that you asked and others, and then people have to make up their minds. And obviously the only reason that I can give, other than it was there, as to why I wrote it the way I wrote it, is the reasons that I gave. I can't go beyond that. Now, I know that sometimes that isn't satisfactory. If I put it in a joking way, and this doesn't deserve a joke, it's like Senator Heflin used to tell the No-Tie Hawkins story. The No-Tie Hawkins story was his friend the judge. He sees him and he says, Judge, why did you decide that case against me? Just because I didn't wear a tie. The judge says, no tie. I certainly wouldn't decide a case against you for that reason. Why would you think I would decide a case against you for that reason? He says, well, it would be better than the reason you gave. So that's all. I can't comment on. You know, I wrote my reasons down, and you'll have to decide.
Could we take just one more question?
Yes, all right, in the back.
I'd like to get your quick comment on three things. Number one, international arbitration. What's your opinion, given the fact that we live in a fairly interconnected world? Number two, what's your opinion about the court in La Hague? And number three, something you mentioned.
What was the first?
International arbitration taking the place of courts. And the third thing, does a sovereign really lose his immunity if he's kicked out by an unlawful military coup?
Who is that?
Thank you.
Who did he say? Oh, his sovereign immunity. On the sovereign immunity, the last one first, what we decided in the cases, that was Mrs. Altman, that the sovereign, there are many forms of immunity. And with Pinochet, there were several that were up. On the particular one, which is the immunity because I am sovereign, if you're not sovereign, you don't have the immunity. The reason, in a nutshell, is because the purpose of that kind of immunity is to prevent the courts from getting involved in the workings of the foreign government at this moment. That's what we said. So that was the reason. And that's why she won. And effectively. I'm oversimplified. And the second was, what do I think of the International Court of Justice? I think it's there. It's in treaties, and one of the reasons I was unhappy in Medellin was I thought and one of the reasons the President of the United States wrote the letter to the governor of Texas. We agreed, we had a special protocol, we said that we would follow the opinions of the International Court of Justice. And then he was saying we were not doing it. And the court, I objected to the court's decision there, I dissented. They said, well, that may be so, but that's as a matter of international law, it's not as a matter of the internal law of the United States. And I explained what I thought was wrong. That was wrong. Now, what's the first? What do I think of what? Arbitration. There's a whole section on that. That's really interesting, and it's a little technical. But vast numbers of business cases, certainly most, are being decided through arbitration. And the court and the relation of the arbitrators is very complicated. And the subject of New York Convention, a lot of treaties. And if you get a judgment of an arbitrator, your chance of getting it enforced very high, very high. That's the New York Convention. And the relation of the courts involves certain specific recurring issues. In particular, they don't enforce it if it's against the public policy of the state. That'll come up more. What is public policy there? What counts as public policy as a reason for not enforcing the arbitration? I once asked the head of the International Arbitration Association, I met him, I said, why is it, that so many businesses are now going to arbitration? What are the real reasons? Why don't they? In our courts, we find that too. Businesses are staying out of the courts, and they're going to arbitrators, even if they're not international. I said, why? He said, well, you don't want to hear. I said, no, I really want to know. Tell me, what is the reason? Is it cheaper? No, he said, it isn't that much cheaper. Shorter time? No, he said, it isn't so much. He said, well, one reason is because we can keep it confidential. They want to do that. He says, actually, we think a lot of it is that we get better judges.